What's going on, everyone? Welcome to another episode of The Remote Real Estate Investor. I'm Michael Abbaum, and today I'm joined by Brian Bradley, asset protection attorney, and he's going to be dropping some knowledge about all the things we should be aware of as real estate investors when it comes to protecting our assets. So let's get into it. Brian, what's going on, man? Thanks so much for taking the time to hang out with me today. I really appreciate it.
Dude, absolutely, Mike. Thanks for having me on. It's going to be an important topic, a fun topic. I'm going to try to keep it fun and not legally dense. And, just like I'm not anyone's, attorney here or legal guru. So we're just going to be talking generalities, right?
Right.
I think we're going to learn a lot in this. It's going to be a lot of fun. And as you're building, scaling, making more money, you're getting a bigger red button on you. And so like this world of what we're going to be talking about, asset protection is kind of a big deal. There's just a lot of ways to skin a cat. Different layers, different strategies for where you're at in your life. So, I think as we break these down, hopefully I can, make a little bit more sense for you and your listeners.
Yes. Well, thank you. I am super excited to learn a lot because before we hit record here, you and I were chatting about some of the topics we're going to be covering today. And I was like, what is that? Totally brand new. So I'm really excited from a self-serving perspective. So give everyone the quick and dirty background who doesn't know Brian Bradley, who you are, where you come from, and what is it you're doing in real estate today?
Yeah, absolutely. So, I'm an asset protection attorney. We were talking about it off recording, like from Lake Tahoe. So, big snowboard ski, ski bum, lake bum.
Right on.
Got into asset protection from the litigation side of the law. I was selected to America's Best Attorney list 2021, 2020, Super Lawyers Rising Star 2021, 2015.
My guess is that's not like an online survey you filled out to get that designation.
No. And that doesn't do with me. That's literally just people that you whoop their butt up in court and then they recommend you or judges recommend you. And I have nothing to do with it. And it's actually pretty, I appreciate even just the nomination, let alone winning it, to where I think they only say 1% of all attorneys in the nation even get nominated for those awards, let alone then, 1% of those even get, picked as a winner. And so,
Congratulations.
Thanks. Yeah. And for me getting into, asset protection, which we'll define what that is, in a minute, like that'll be like, I think our base starting point. I just got into this weird area of law because one, I like money. I like investing. I like, not paying as much taxes as as I can. And as you grow, you got to be smart with your money, right? And who can take it from you. And so as a trial lawyer starting out, I just had so many clients who were being sued and their lives just turned completely upside down coming to me after they were already being sued. And at that point, you're just too far down the rabbit hole. It's like going to get car insurance after you already got in an accident or, home insurance after your house already, caught on fire. It's just, it's not going to happen. And so I see a lot of people thinking that they don't need to do anything is another misconception. It's kind of human nature, right? Like I'm just going to ride Lady Luck. I'll deal with it when it hits me later on. And that's just not how anything that needs to be proactive in the legal sense is going to work, like insurance or asset protection. Wishful thinking is not a protection tool. That's how you end up losing everything. Like go to Vegas and hit the roulette table and see how long your wishful thinking is going to last for you.
Right.
Right. Or, as you're leveling up, people forget about this. Like as your wealth is leveling up, you're leveling up. You don't level up your protection. You don't level up your insurance. People go buy an umbrella policy, but they don't realize, well, an umbrella policy is just like everything else, right? It just provides more excess and money to, for coverage, but it still has the same escape clauses. Like there's no insurance in the world that's going to say, okay, hey, if I go punch you in the face, are you going to cover it for me? No, like they don't cover you for intentional wrongdoings or allegations of fraud and intentional wrongs. And so that's how they have their escape clauses out, especially for very big cases. If you're talking about like $1 million or more lawsuit. A couple other big misconceptions that we need to address as we lay this landscape is just, the revocable living trust. People think like, oh yeah, I have a trust, right? Like, they don't realize trust. There's a lot of different types of trust. Your family estate plan, your revocable living trust, they're not designed to protect you while you're living. They don't have the legal teeth to be able to. So once you pass, they're only designed to avoid probate, not protect you while you're living from lawsuits. And then over the last 5 years, I've noticed this massive misconception about the use of limited liability companies, LLCs. And they just think that they're like, silver bullet Dracula slayers. And I'm like, do you guys Did you guys miss like first word, first letter, like limited? I tell you in the name. Like, where has this happened? Where does this come from? Like, they're not hiding the fact. They tell you, like, they titled it telling you limited liability. Yeah. So like now we have to re-educate people on this. Like, yeah, don't put everything in the world under one LLC. Otherwise, if it gets pierced, you're going to lose it all. Like, what are you talking about? Which we'll break that down, in a little bit. And then the sad thing is, like, and I think it's worth explaining, is just if you just look around and you look at, our legal system and the world we live in, it's just broken. It's a broken system, and we're a sue happy nirvana. And just to like kind of lay this framework down a little bit more, we're no longer about justice. We're about redistributing wealth from the haves, which is you, your listeners, people trying to grow and accumulate more, to the have-nots. And over the last 40, 50 years, things that didn't happen in the past or that weren't allowed to happen in the past, like contingency fee lawyers or law firm advertising, they're commonplace. And then this created a cultural shift of a predatory legal system that's no longer about justice. So it's about profits now. And then when you get in the world of high net worth and affluent families and wealth, this level of protection, now we have to deal with taking a macroeconomic, more of like a global look about what's going on. And the big picture here is really that we have a global financial system that has structurally deep-rooted issues. We have government-backed fiat currencies that are now in question. This is also including the US dollar. So don't think like just because we're in the US, we're exempt from all of this. Monetary policy today, the one that exists is, inflate or die. And then you got governments looking for deep and accessible pools of financing, meaning our money, the hard workers, the people who are investing, along with financial repression, monetary and economic manipulation. So this just adds all the challenges that we have to deal with when we're looking to protect, your assets. And so asset protection is that modern best bet to level this playing field by using a lot of the tools and the combination of the tools that we're going to talk about today to make it very hard for you to be collected on. And so what this is really about is just like a talk about giving you peace of mind, lifestyle preservation, and, really just how collectible are you at the end of the day.
Love it. Love it. Well, I am all about doing things to help peace of mind and insulate ourselves from the world at large, the sue happy world at large. So help us understand, Brian, like what are some of the things when someone says asset protection to you, like, Brian, I got to protect my assets. What does that mean to you? What alarm bells are going off in your head?
Yeah, absolutely. One is like, do you understand the difference between tax mitigation and asset protection? And I've been getting this a lot, especially this last year, obviously, as we see what's going on, with inflation, taxes, and everything right now. Asset protection is not tax mitigation. Like, that's your CPA and wealth manager's job. If creating an asset protection plan or an asset protection trust or going offshore, were to create tax havens, like, one, that's illegal, it's fraud, so the system won't work, and then you go to jail for that type of stuff.
So don't do that, is what you're saying.
Don't do that. That's not what this is about. So people always like, I want to protect my assets and I don't want to pay taxes. Completely two different things. The asset protection plan is to protect your assets from predatory lawsuits and litigation, not saying I want to not pay taxes. That's tax mitigation. Talk to your CPA and wealth managers. First, lock down your assets from lawsuits, because if you get sued and lose everything, what's your miracle working CPA going to be able to do for you if you have nothing for them to work on? So order of operation, protect your assets, then let them work through the system that's created to actually like mitigate, forced depreciation, all those wonderful things that they do, cost seg analysis.
Yeah. But Brian, to that point really quick, I'm just curious, like, do you work with a lot of CPAs? Because I can envision a scenario in which the legal side of things is super buttoned up, super tight, but maybe isn't very tax efficient. And so my guess is there's probably a happy medium or some input that a CPA or wealth manager can inject into the situation to help make both things as tight as possible.
Correct. You got to talk, the issue generally is people don't involve their lawyers until later on down the line. And it creates a lot of problems. So for example, a lot of CPAs will set up S corps for investors, especially real estate investors for some reason. And great for tax purposes, horrible for litigation. And I get this call a lot, and most of my clients are calling with like $50, $100 million of real estate all stuffed in one S corp. Okay. Great. Again, for tax mitigation, horrible for, let's say you get sued and now your S corp and all the shares get frozen and ceased. There's nothing I can do for you at that point. I can't move assets out. And then even if I wanted and you realize like, oh my God, I have so many pieces of property under one corporation, like this is very risky. I need to start, diversifying out and pulling these assets out. you're stuck. You're not going to be able to. And I just had this call yesterday with a potential client. The reason is when all the benefits of the S corp, right? Deferred taxation and all this stuff. You're kicking the can down the road. Once you start taking the assets out, you have to pay the money back. And so people don't generally have millions of dollars just sitting in their bank account saying like, okay, hey, I feel like, taking all the assets out of my S corp now I'm going to go and pay the piper and the IRS. So because you don't have that money sitting around to pay the IRS and the taxes, we can't move the assets for you. And I'm not going to force you to go, and have the IRS coming after you to collect on you and move the assets out anyways, because now you're just creating a bad situation for the client. So the lesson here to learn is if you're thinking of investing, you need to talk to both the lawyer and the CPA, because a lot of CPAs, they shouldn't be giving you legal advice. They're not lawyers, and they're not going to understand the aspect of, what happens actually in court with S corps and C corps when it comes to litigation, and why we don't want to use those to protect your assets. So we have to all talk together. The problem is I get the mess after the fact, and then I have to start cleaning things up afterwards. And so when done right, really, the modern, estate planning is asset protection. What we're doing is creating legal barriers between your assets and your potential creditor, the person suing you, the person trying to come after your money before it's needed. And that's it. It's like a safe for your gold or your guns or your valuables. Anything of value, you want to put behind a legal barrier and out of your personal name so that it's not easily attached with a lien or reached. And so just like the rich, I really like the Tony Robbins saying, success leaves clues. The rich don't own things in their personal names. Their businesses do, their trusts do. They just get the beneficial use and enjoyment out of them while separating out that legal liability. And we do that through just like different tools and mechanisms that we have, kind of like key concepts and roadmaps like LLCs, limited partnerships, and trust.
Got it. Okay. And so when real estate investor comes to you, they're just getting started. They are moist clay. You can totally mold them. They don't already have a bunch of issues. What is your go-to ideal scenario for asset protection?
Yeah. So you're just starting out. You're a greenhorn. Really, it's just going to be an LLC and insurance. And that's where you're going to go. Okay. And as you think about how to use these systems and how to grow within them, okay, I want you and your listeners to think about winter. Okay. We were talking about this before we started recording. I'm from Lake Tahoe, snow, cold, snowboarding, skiing. I lived in Michigan, freezing cold, Arctic, minus 40 degree weather for a while as well. I'm in Portland, damp cold. You got to really layer up. And so the first entry layer is your base layer when you're getting dressed. It's going to sit on your skin. This is the equivalent of an LLC in insurance. This is, when you're just starting out investing and you have 0 to 3 units or, 0 to 3 properties, your exposed net worth generally is at 250,000 net or below. And then as you grow and you add more assets and you hit around that 4 unit or 4 property mark, you could be starting to invest in a couple different states as well. You have now around 500 to 700,000 exposed nets. What you need is a mid layer, which is usually a little bit thicker. It's going to be made out of a merino wool sweater, or for you ladies, a cardigan. This is your management company, like a limited partnership. And I can break down that later on if we have time. And then when you hit around that 1 million net worth mark, you're going to want a water shell waterproof layer. This keeps you nice and dry and warm when the weather is really bad. This is your doomsday lawsuit protection layer. It's going to be an asset protection trust. And specifically for our clients, we use a hybrid trust, which is combining an offshore trust and domesticating it through the IRS. So when a client comes to me, I realistically know you want 4 things. One, you're going to want an effective plan. 2, you're going to want to control your plan. 3, you want reasonable and sustainable costs. Depending on what layer you're at, it's going to be individual per the client profile. And then 4, you want a plan that's going to be easy to maintain compliance on with the IRS. I can create the strongest thing in the world for you, but if you're not going to be maintaining it and you don't want to do the IRS compliance with it, eventually you're just going to stop doing it and the whole system falls apart. So as you go through the evaluation process and you're talking to different attorneys and you're vetting the process, just remember the acronym ECCC: effectiveness, control, cost, and compliance. And as long as you can start checking off all those boxes, you're going to have a really good system. If you want, I can break down the first layer if you want to start to kind of go there, like LLCs or just really wherever you feel like directing this.
Yeah, so I think our listeners probably have a good handle on LLCs, but I would love if you would walk us through what this hybrid trust is, because it's not something that I'm familiar with. I never heard of before. So
Yeah, and I think the reason one is like not many people focus on asset protection at a high level. I think of it as like insurance. A lot of people, one, they're not only purely asset protection attorneys, right? They're generally like business attorneys who do some asset protection, or they're real estate, attorneys who do a little bit, and they take a continuing legal education course, learn about LLCs, and it kind of stops there. And like insurance, they kind of try to cast a large net nationwide. Well, what's one thing you can cast nationwide? An LLC. And so I kind of think that's why like the base layer knowledge kind of stops there, because not many people just focus on, very, very strong protection. This comes with the asset protection trust. So it's this final layer, the bad weather, the outer shell waterproof layer. It's this asset protection trust. It's going to be really the heart and soul of the system, especially when you have over 1 million exposed net wealth. And what I mean exposed is like your 401k is exempt. So I don't include that in a net worth evaluation because it's already a RISA protected. Some states, like if you're a Florida resident, we have a very strong homestead exemption of 100% of your primary residence. So I would take that out of the equation too, depending on the state you're in the homestead. So what we're looking at is exposed, unprotected net, equity and wealth. All right. The great thing about trust is that they can be sculpted to fit how you need them, and they can morph as you need them without dealing with funding issues that you're going to fall into with LLCs and other business entities that get their protection pierced, meaning now you're going to be held personally liable. So I just love trust, and having a trust at the very top of the planning is very powerful. And then this is where picking the proper jurisdiction for a trust really comes into play. The standard 101 trust that I'm sure like everybody's familiar with, started in the 60s, is the family revocable living trust. So, like when trust don't die. So then when you do, you act and you fund your trust, which a lot of people forget to do. Like, oh, I created my estate plan and then they never transfer title into it. Remember, fund the trust if it's just, your revocable living trust. The benefit it is when you pass, you don't have to go through probate. You can just skip the court system and probate, and it changed the landscape of estate planning. Then you have what are called land trusts. For real estate, you hold your land and then you connect them to an LLC. But land trusts don't have any protection in and of themselves. They're only as strong as the LLC that they're connected to. So they're just a privacy mechanism, not a protection mechanism.
Okay.
From there, you have higher levels of trust. They're called asset protection trust. And I really want to spend the time, with this and break down the three different types. And after this, I think you and probably 99% of your listeners are going to know more than 99% of all the attorneys out there about asset protection trust.
Love it.
They came about in the early 1980s, and so an asset protection trust is what's called a self-settled spendthrift trust. All self-settled means is that you created it for yourself. They're for you, by you, as your own beneficiary. And they have very important spendthrift provisions in them. So this lets you protect your assets while you're actually living, from creditors trying to sue you, from not having to relinquish control of your assets. The difference is that they allow you to protect your assets, not just for your grandkids, but for yourself, which you weren't allowed to do in the past. And then, like I said, you're probably familiar with another type of self-settled trust, the revocable living trust. They're the same in that they're self-settled, created for you, by you. The difference is that with an asset protection version of this trust, it includes these critical provisions called spendthrift provisions. And what spendthrift provisions are is they are provisions that allow you to protect your assets from the creditors. They're the actual teeth behind it. And for those to work, the trust then has to be not revocable, but irrevocable. So it's a very different type of trust, just like chocolate and vanilla, both ice cream, just different types of ice cream.
Yeah.
Now, this is where the fun really starts to actually happen. There's two major school of thoughts here. You can go international, meaning offshore, another country, jurisdiction. You hear about Cook Islands, Cayman Islands, Belize, Bahamas, or domestically here in the U.S., Nevada, Delaware, Wyoming, Texas. So you can set them up here in the United States. And, if you don't mind, I think a great way to talk about it is just kind of talk about it through historical context, because then I think if you understand the foundations of both offshore and domestic, then you understand the principles of how we combine them together and why you want to.
Yeah, let's do it.
All right, cool. So again, you really have these three options, right? You can establish them offshore, you can establish them domestically, and then we can hybrid them out like a hybrid car. Take the best of both worlds, put them together. So from the historical concept, The offshore trust actually came first in 1984 when the famous Cook Islands, they created the first asset protection trust. I like and choose the Cook Islands if and when it's applicable, just because it literally offers the best home court advantage. And why it's the best is because asset protection is just what these trusts in the Cook Islands were specifically drafted for. And the power here is they have this wonderful word called statutory non-recognition of any other jurisdictional court orders in the world, including the United States. And so what this means is that if you have a judgment against you in the United States and then you took it down to the Cook Islands, your U.S. judgment is literally worthless. It literally has no value whatsoever. Statutorily, the Cook Islands, they're prohibited from recognizing it, even from their own constitution. And so if somebody wants to sue your trust and it has a Cook Islands, clause in it, so it's a Cook Islands trust, they would have to start their case all over from scratch. The person suing you, they're going to have to prove their case beyond a reasonable doubt. This is the murder standard, the highest legal standard in the world, the 99% sure standard, not that, 51% preponderance of the evidence. I'm not sure. We don't know what happened, but we don't like the way they look right now. So let's just give it to them. You can't get a contingency fee attorney to represent you because they're just not allowed down there. It's unethical in the Cook Islands, just like it used to be unethical here in the United States, but then that got changed in the 60s. The claim, meaning the lawsuit, it's not amendable. So what this means is that it can't be changed or amended after the discovery process starts, like we can do here in the United States. Like we can literally just say, okay, I'm suing you for this, dig around, start discovery, then completely change what we're suing you for because we started using it as a fishing expedition. The person suing you, this is just like standard trial tactics. Is like, okay, hey, let me just flood you with discovery and like start poking around and say, oh, hey, we didn't even know this was right here. Now I'm going to add this to the complaint and sue you now for this. Looks like a better cause of action anyways. Can't do that down there, but we can do it here all the time in the U.S.
So it sounds like I need to go move to the Cook Islands.
Well, here, maybe not, right? Because, there's cons to things. I'll get to the cons in a minute.
Okay.
So the person suing you, they're going to have to front the entire court costs, find a judge from New Zealand, and if you lose, you pay. And I honestly think this is one of the worst things that we don't have here in the United States. The loser doesn't need to pay the legal fees and the cost of the winner. So if you get sued for something completely bogus, a frivolous lawsuit, and you spend $200,000 defending yourself on legal fees, then the judge finally is like, this is ridiculous. I'm throwing this case out. You're still out $200,000. The person who sued you, they're not going to be getting the bill for that because our legal system in the United States, that would discourage lawsuits. And our legal system is run by trial lawyers who don't want to discourage lawsuits. And there's only a 1-year statute of limitations. So if you go back to those 4 things I mentioned, right? Remember, like effectiveness, cost, control, compliance. Effectiveness, 5 out of 5 stars. Nothing beats statutory non-recognition. So what about the other ones, right? Control, cost, and compliance. This is kind of his kryptonite. These are the drawbacks. If you're going to be purely foreign, like a purely foreign trust, you have a lot more IRS reporting, compliance, and disclosure. So you have these things called IRS forms 3520s, 3520As. What this is a full balance sheet disclosure of everything the trust owns, and sometimes even the entire trust agreement to be disclosed and submitted to the IRS. And it is expensive for these IRS forms to be done every year. Also, you're going to have FACTA compliance because you're going to have a foreign bank account at that time. And of course, for these trusts to work, you're going to be out of control of the trust. That's why they work so good. That's why they're the creme de la creme. And clients are just not comfortable with this. And so while we literally have the most effective trust in the world by far, it's not something that I generally start with. I probably only say like 1% of my clients I'll go to a purely foreign trust with, which then brings us right to the second option. Okay, we're not going to be going foreign. Well, what about these domestic trusts?
Yeah.
They came about 10 years later down the road, of all places, Alaska started it out. And then not to be outdone, obviously, you're going to be like, well, hey, we're Wyoming and Nevada and Delaware. Like, this is what we're known for. So we're jumping on the gravy train, right? And then about 19 other states now have created some form of asset protection, self-settled, trust statutes. So what you're seeing is the state starting to jump on board, saying, yeah, our legal system is a threat and things have to get done to protect your assets. And so asset protection in the United States is very important to understand, is valid. It's just the concept is like how you go about doing it is very important. The issue with the purely domestic Asset protection trust is that, we live in the United States of America. We have a constitution, Article 4, Section 1, full faith and credit clause. What this provides and means is that every state has to grant the full faith and credit to the judicial proceedings of every other state. What means, what it's telling you is that, for example, Nevada can pass and has passed an asset protection statute, okay, but it cannot ignore a California or a Washington or another state's court orders. So where the Cook Islands can literally just throw that California judgment in the trash, Nevada can't do that. Nevada has to respect it constitutionally and even litigate it. And then you have courts that are just simply ignoring the choice of law clause. So, you literally have Bately versus Mordison, In re Hubbard, Kilka versus Steelman, Dill versus Dale. All great facts, all great cases. They should have won those cases, and judges literally just use their superpower, public policy. We're ignoring the choice of law clause. Trust is breach. Breach means loss of assets. That's just completely unacceptable. And so because of the case law that we're seeing, I'm not a big fan of a purely domestic asset protection trust or anything purely domestic without something offshore built into it. This is why I prefer the hybrid version called, we just call it a bridge trust, but it's really just like a hybrid trust. Think of them like a hybrid cars, okay? What we're doing is just combining the best of both and then making a better product. And so these trusts have been around for almost 3 decades. So they're not, the new lady to the dance. They've been around for about 30 years now. And at the end of the day, what you're doing is taking a fully registered foreign Cook Island offshore asset protection trust with all that 40 years of solid case law. Again, so it's fully registered offshore from the day we create it with the offshore trustee. They're there in standby just in case you need them. And then we build a bridge back to the IRS for IRS classification. So the IRS is literally taking this foreign trust and then they're classifying it as a domestic U.S. trust by complying with USC Section 7701. It's called the court test control test. And so because of that bridge, as long as we have our compliance in place, we stay classified domestically. And what this does is that the trust is now going to be cheaper to create. So generally a purely foreign trust is going to cost like $45,000, $50,000, even $60,000 plus $12,000 a year to maintain. Very expensive. A hybrid trust is going to be cheaper. You're generally going to be talking about $23,000 to $30,000 to set up a hybrid trust plus no IRS tax filings whatsoever while you're domestic because it's classified as a domestic U.S. grantor's trust. So you have no more IRS tax filings unless, God forbid, we have to break that bridge. And now you also get the power of the offshore trust if and when we need it. It's in our toolbox now, just like a contractor who says okay, hey, I don't need to use all my tools today, but I'm going to need them possibly at some point. So now I can use them as I need them. Versus coming to me later on after the fact. Oh my God, Brian, I mowed somebody over with my car. Can you help me? I want that foreign trust. Well, no, sorry, it's after the fact. I can't do it now. But if we had the hybrid, I could have engaged it. So that would be during a state of duress. We would break the bridge, stop being in IRS compliance. You are what you are, a foreign trust. Until that point, you want to be classified domestically. So the hybrid trust is just very, very effective. You maintain control of your assets. You maintain control of the trust right up until that doomsday scenario where you don't want to be in control of it anymore. Maintenance and compliance with the IRS, very simple. So at that point, you've now checked off all the boxes: effectiveness, cost, control, and compliance. Check, 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 check. And so this is where, for our clients, we generally are starting with these hybrid trusts.
Wow, this is wild. This is super cool. And so are you thinking that most folks that are in that kind of $1 million of exposed net worth, this is where that starts to make sense?
That's exactly so our main client profile that comes in, you would think they'd be tens of millions of dollars for it. It's realistically, I would say 75% of our clients generally are around that 1.2 million exposed net. Some high risk, probably like a doctor, surgeon, lawyer, or just straight real estate investors. Some of my favorite clients, nurses, firefighters, cops who self-funded their retirement through cash flowing properties, and now they're about to retire and they realize I can't lose all of this now because this is literally my nest egg and my legacy.
Yeah.
They need to lock it down. And so you generally see the average client profile is 1.2 to 2 million of exposed net with some risk. And it makes sense at that point. Yeah, get the LLC, get the limited partnership, get the trust for $30,000, lock down $1 million plus, and then sleep well at night. That's when the investment kind of makes sense for this type of protection.
Yeah, that makes total sense. And what would you say, because I would imagine after listening to this, folks might go to other attorneys they work with, mention this type of hybrid trust, and they might be told, nah, you don't need it. LLC is good enough. I mean, what's the kind, I know we've talked about kind of a counter argument, but how does that conversation get had?
Well, most of the time I would say like the estate planning attorney, they won't know about this because their knowledge base, is just not going to be around, let alone foreign trusts. I mean, there's not that many people who even know like that much detail about how a foreign trust works, let alone using the incorrect domestic asset protection trust. You know how many times I have California residents using a Nevada asset protection trust, and the person who set it up for them, like the lawyer, has no idea. Like, okay, what about this case, Kilker versus Steelman, 2012, California case that said, hey, you're a California resident. We don't recognize asset protection trust because we don't have the statutes here. So your Nevada asset protection trust, sorry, it's worthless. It's not going to work. So unless you go to an actual specialist and say, hey, here's the case law, here's what's going to happen down the run. Most people don't have that level of education because they're not in that world. They don't exist in it. So I feel bad for the clients because where's the knowledge come from? You think you're going to an attorney who would specialize in this, but you're not taught this in law school. You're not taught this for the bar exam. So how you develop this level of knowledge is just, did you get into the right group of people and were you passionate about it enough to like transition your practice into it? That's why I do these talks, is just to educate people. And, just the base thing of like, why not just an LLC? They're disregarded entities for tax purposes. So if they're disregarded for taxes, that means it's disregarded to you for lawsuits and liability, meaning you're pierced. If you're using them for real estate, they're not businesses, they're holding companies, which means the number one argument that will win and pierce that every time is, well, Your Honor, this is an actual business. It's an extension of Michael, is just a holding company. Boom, you're pierced. Funding issues, bad accounting systems. Like there's 4 ways to pierce that veil right there, and I don't even have to think hard about it. Charging order protection. I mean, like, what state do I go set these things up in? You know how many times I hear people like, oh, just go create a Wyoming LLC. Are you a resident of Wyoming? Is the asset in Wyoming? And if the answer is no to either one of those, you just tried to buy another state's jurisdiction that you have no connection to. Try bringing another state's laws to like California or another state that you're not connected to and there's no reason to. You're going to get laughed out of court. Like, it's just, you can't go buy other states' more beneficial laws and bring them, to another state that that has no jurisdictional connection to it. And then anonymity is the other like really like flavor of the last like 2 years, is like, oh, create this anonymous Delaware or Wyoming trust and ghost a lawsuit.
Right.
Well, that's not how these work. That's not how anonymity works, but that's how it's being sold by, law firm salesmen and promoters. Create this and get a really crazy operating agreement. And the next thing you know, like, you're never going to have to show up in court. I'm sorry, you have a personal agent of service for these out-of-state law firms. Their sole job, like let's say Mike here is my, personal agent of service. He's going to get my service and he's going to say, hey, Brian, here's your service. Guess what, dude? You just got served.
You got to show up in court.
Up in court now. Anonymity's done at that point. So the only way that anonymity works is you show up to court. A judge is going to say, hey, you're getting sued for $1 million. Here's your, asset disclosure list. Tell me everything that you own because we didn't know what can be collected on or not. At that point, anonymity, or quote unquote, air quotes, secrecy is now up to you. So you're going to decide, am I going to lie under oath and hope to God I don't get, my operating agreement will hold up and commit perjury in court, or do I just disclose it? So like, you're the weak link at that point. And then if you lie and commit perjury under oath, you're going to jail on top of losing your assets. So it makes more sense just to say, hey, create a proper asset protection plan, LLC in the state that it's at, layer it up into a management company. Once you hit the net worth, put in the trust, and then sleep well at night. Because at the end of the day, I don't care if you lose your lawsuit. I care about if you're collectible or not. Like, you can lose the $10, $50 million case. If the asset protection trust is set up strong and in the right jurisdictions with the proper exit strategies, doesn't mean that you can be collected on. And then it lets me settle a case for a penny on the dollar.
Dang. This is nuts, Brian. This is earth-shattering stuff. We got to have you back on to talk more about this, but I want to be very respectful of your time, get you out of here. For people that have a similar response to me, are like, holy crap, I got to call this guy Brian immediately, learn more about this, reach out for your services. What's the best way for folks to get in touch, get a hold of you?
Yeah, one great resource is jump on my website, www.btblegal.com. I use it more as an educational resource with a lot of case law, client studies. I just want you to be educated at the end of the day. Like, listen to this. Here's the case law. That's what lawyers should know about, especially trial lawyers. That's why I'm a good trial lawyer. I tell stories through case law. And another great way is just through my email, Brian, Brian at btblegal.com. I'll get, free 30-minute consultation, whether we're a great fit or not, we'll figure that out over the phone. I would just rather have people have an educated decision and then they can go shop around.
Love it. Love it. Well, hey man, thanks again for coming on. Really appreciate the time, and we'll definitely be in touch.
Yeah, for sure. Thanks, brother.
All right, everyone, that was our episode. A big thank you to Brian for coming on, talking about a lot of things that we've never heard before on the show, and definitely bringing up some excellent counterpoints to be thinking about. As always, if you enjoyed the episode, feel free to leave us a rating or a review wherever it is you get your episodes, and we look forward to seeing you on the next one. Happy investing.